Good morning, everyone. Welcome to the webinar today with myself and Alex Cook on when things go wrong, arrears and possession. I started the broadcast a little bit early and we are also recording to make sure that you guys can get a copy of this afterwards. So just want to do a quick bit of housekeeping. There might be a few more attendees yet to join, so I'll try not to repeat myself too much. But first and foremostly, on the right-hand side of your screen, in your webinar box, you should be able to see a comments section. In there, you should be able to ask any questions that you have. They are either private or open to everybody. You can specify that. We will answer the questions throughout the webinar. However, we will also do a dedicated question and answer session at the end of the webinar. So if you do have anything that you've got now, stick it in there and I'll make sure that we get through it during the webinar. Otherwise, we will run through them at the end. So we're just going to give attendees another 30 seconds or so, and then I'll run through today's webinar and introduce ourselves properly. So if you just bear with us, we'll just see if anyone else needs to attend. Okay, so we've got a couple more attendees there. I'm just letting you know that we did start this session a little bit early. And just to quickly repeat on the housekeeping, there is a questions comments box down on your right hand side of the screen, and you should also be able to see the slides on our screen. If you're having any difficulties with that, please do let us know. You can use the chat section as well, in which you can talk directly to myself or you can talk directly to the group. So feel free to use those and I'll make sure that we respond as and when we go through. So first of all, let me introduce you all to the webinar itself, which is when things go wrong, arrears and possession. So we're going to talk today about a couple of things that we get questions about from landlords a lot. So first, introducing myself. Those of you that don't know me, and I think quite a few of you do now, I've been with MakeUrMove since 2008, so I've got 10 years experience. My experience comes as a landlord, as a tenant, and also as an agent working with MakeUrMove. MakeUrMove itself, it was a company set up as an alternative for landlords and tenants alike. The aim behind our business is to provide a supportive role to landlords and remove costs using technology, which is always powered by people. So we don't aim to remove people from this. I'm going to introduce you to Alex. Alex will let you know a bit about his background.
Yeah, morning everyone. Alex Cook, that's me. I am, as you can see here, specialist litigation solicitor. I've been working in disputes litigation specifically for over 10 years. Slightly dull list, apologies, but obviously in terms of my background, I was called to the bar as a barrister in 2007, and now I own Helix Law, which is a specialist litigation firm of solicitors. I mean, we act for landlords, investors nationally, and really we're only dealing with problems. So there's an awful lot we don't deal with, but this is bang on point for us in terms of arrears, possession work, and really problem solving.
Great, thanks Alex. So we're just going to run through what we're going to go over today. So we'll take a quick look at the problem itself, which Alex will help us understand. We'll have a look at how to set up a tenancy correctly to avoid these problems, how important tenant vetting is, how you should be handling your arrears, when to serve notice, how important it is to engage a legal representative, how you deal with an eviction, what the post-eviction process is, and then what the landscape now is for private landlords and moving forwards, what that's going to look like. So we'll follow up with the question and answers section. The first one is a big problem. So I'm going to hand over to Alex, who's going to talk to you about some statistics within the residential lettings. Alex?
Sure. Thanks very much, Alex. Yeah, so I mean, just taking a step back here, high-level stuff. We know from the most recent English housing survey, so this is England essentially, 2017, the most recent survey, quite a high figure here. 9% of tenancies either have been or are in arrears. So this is something that every landlord at some point in time may come across. So it's certainly something to just be aware of at a high level. Of course, the flip side of that same point, and I kind of just reminded myself of this before starting today, that does mean that 91% of tenancies have not been in arrears. So just in terms of understanding this, it's clearly something to be aware of. There are some steps that you can take to reduce the risks moving forwards, which we'll run through. But ultimately, I think tenancy problems, arrears, it's something that all landlords and investors may well come across, but equally I think sometimes the perception of the fear can be higher than the reality, particularly if you do take steps. Again, I was looking at some Ministry of Justice figures here, sort of exciting weekend reading I like doing, and over the last 5 to 10 years, the reality is that claims are down. So again, it might well be that's not your sort of instinctive view on this, but claims are decreasing, not increasing in this area. So you obviously want to be in the 91%, and really that's sort of what we're trying to do here in helping you. Average costs of eviction, again, just at a high level, there's any number of different service providers landlords might use in this sort of an area. Average cost, I would say, between £1,000 and £2,000. That's broadly speaking what you're in for when you take into account the costs of the providers doing the work, the court fees, obviously, to be incurred as well, but it does vary, of course, as do the services that are provided. In terms of average times to get an eviction, now these can range hugely. The most recent, again, MOJ, Ministry of Justice statistics, they release data on the number of claims, the type of claims, etc. You're talking months in terms of national averages, certainly. I would say that in terms of our experience, and we deal with hundreds of these sorts of claims, quite literally across the country, our experience is that the average time to obtain an eviction is about 3 to 6 months. It significantly depends on how busy your local court is, but that's pretty much what you're in for in terms of if there is a problem, if you have to look at issuing a claim, etc., etc. So it does vary, but really that's what you need to be thinking in terms of both time and budget. And I guess really, again, trying to keep this at a high-ish level at this stage, this is a business. You're in the business of providing property and letting property to tenants. You can occasionally hit problems. This is what you should be budgeting or thinking about in terms of if the worst should occur at any given time.
Just to touch on that with you, Alex, the cost of the eviction that you've quoted there, that obviously doesn't include arrears itself.
No.
So that has to be considered too, which I'm sure we'll touch on as we go through.
Right. Absolutely right.
The time too. So this is a quick question that we've had through. So is there a difference between the time to get an eviction with Section 8 versus Section 21? So I think we're going to touch on that a little bit further down, but I don't know if you want to ask.
We are. Yeah, and it's a really good question because on the face of it, and I mean, we will come on to this, but I'm happy to tackle it now since it's been raised. Section 8 notice, on the face of it, much quicker. It's a 14-day notice, whereas a Section 21 notice is a 2-month notice. But that disregards the process that then follows. I'm not going to go into that in more detail now. I think we'll come on to that in a moment. But for reasons I'll explain, Section 8 is not always the quicker route. So perhaps if we come on to that, Alex. But the classic problems here, as you can see, tenant won't leave. You therefore need a court order, or you're at risk of unlawful eviction. Nobody wants to get into that murky world. Or again, the classic tenant not paying the rent. What can we do about that as landlords to try and, as I say, mitigate your loss and get that issue resolved?
Yeah, definitely. So you're going on to your more specific problems now. So when we talk about tenants not paying rent, that could be the cause of one of the reasons why you raise a notice, but also the other one, the tenants not leaving. These sometimes can just be, there has been some verbal agreement that they will leave, and then at the last minute they decide they're not going to leave. So
yeah. Both classic scenarios, to be honest with you, Alex. If we look at this, so tenants not paying the rent, well, it's actually legally pretty straightforward. This, 9 times out of 10, that will amount to a breach of the AST, which is a breach of contract claim. So you're going to be on solid ground legally, assuming you have your documents in order, your tenancy in hand, etc., etc. And that in itself will usually amount to a reason to terminate the tenancy. Again, shades of grey on this in terms of how sort of much or how great the arrears are and over the period of time, and that can lead us into the type of notice we serve. But as a very simple, straightforward starting point, if a tenant's not paying the rent that they've agreed to pay, they're going to be in breach of contract, and it is going to amount to a reason to terminate the tenancy. There's a whole raft of process that comes on the back of that so that you can do it lawfully. But I think, again, let's approach this from the positive, which is you can do something about that as a landlord. So sort of let's forget the head in the sand type scenario here. Let's identify the problem and then talk about how we're going to resolve that problem. And that's what we're really interested in here in terms of getting landlords on the front foot in dealing with these issues in your business. Relying on arrears alone in terms of possession, again, I've put here not usually advised, as claims can be more complex and take longer. This goes back to the Section 8 conversation I was just sort of having and the question that was raised in terms of whether or not they're quicker. Section 8 claims are based on a breach of the AST by the tenant. So again, we talk here about rent arrears. That's fine. You have to rely on different grounds, which I'm going to come on to. The reason we don't necessarily like them is that you have to prove that breach in court. That's the first issue. So in other words, there will certainly be a hearing on a Section 8 notice. That's the first problem. So that's time and cost. But the additional problem is that a tenant has a right to issue what's known as a counterclaim. So in other words, they can push back on the basis of that claim. So they may well even admit the arrears or have no defence. But then a classic counterclaim would be, oh, the property's in disrepair, that's why I've not paid the rent. And that opens a whole raft of issues just in terms of the condition of the property, whether or not expert evidence is needed. And this is where you start to see Section 8 claims in particular, so claims based on a breach by the tenant, taking longer. This is the claims that you may hear, they take 6 to 12 months to be resolved in court, etc., etc. The horror stories, all whilst these arrears are accruing. That's usually on the back of a Section 8 claim where a tenant has issued a counterclaim. And it may have no merit at all, but it will simply buy the tenant time or drag the whole thing out and increase the cost for landlords. So for that reason, we say normally, no complete sort of universal rule here, but normally, depending on the circumstances, we'd say don't necessarily rely on a Section 8 notice unless you really are back against the wall and you don't have an alternative. And this sort of leads in, to the secondary point. You usually advise to deal with the reclaim for money separately following possession. If you don't pursue the rent arrears or problems via a Section 8 notice, you can still issue further claims. So, you're not sort of required to pursue them all at once, and you can deal with possession first rather than the arrears and possession at the same time.
We have another quick question on this. So The question is it's almost twofold actually. So I'll go with the first bit first so I can decipher it. If you issue a Section 8 and a Section 21 at the same time, are you able to rely on the Section 21 after submitting claims through the Section 8?
Okay, so that's a really specific question. The truth is that when you're issuing a claim, particularly a Section 8 claim, that is what's known as a claim for possession of land. You would rely normally on both the Section 8 and the Section 21 notice. So it depends how the claim has been issued, but that's the approach that we would take. You might do that if, for example, you're only in month 4 of a 12-month tenancy or something. Well, you can serve a Section 21 after the 4th month, but it won't expire until the end of the 12th month, obviously, because of the fixed term. So it's kind of a hedge against delay on the Section 8 claim. But quite a complex question. I'm really happy to talk about specifics, but it very much depends on how the claim has been actually issued by the landlord.
Yeah, no, totally. We understand that. No, that's fine. So the other part of that question was, if I use the Section 21, can I then take out a separate action for money reclaim?
Yes, absolutely you can. And I would say, and again, this is mentioned in possibly even the following slide, but certainly coming up, to keep in your mind a distinction, a separation between any arrears and possession. Because if I take a step back and I think about this commercially, as a landlord, you don't really want the position to worsen. You're trying to nip this in the bud as quickly as possible. And so from my point of view, I would say, let's regain possession as quickly as we possibly can. And then we can get in a new tenant. We can effectively start mitigating our loss, perhaps help us to pay the mortgage or whatever else lending is going on, or just to make sure that sort of arrears pot is not growing. Yeah. We then left with a sort of a crystallised amount of rent arrears. We can also look at the condition of the property, and you can then issue a separate claim in relation to rent arrears and any damage to the property, etc. So as I say, they're not all the same, this, and I think possession and arrears sometimes get bundled in together, when I would say think about possession first. Let's get possession as quickly as possible and then tackle the arrears.
Yeah, take the tasks off rather than try and do everything together.
Exactly. Yeah, narrow the issues. Yeah.
Okay, well, we're going to move on to setting up a tenancy and how following best practice with this can definitely help you when it comes to arrears and also possession at a later stage. So there is obviously, most of you will be aware now, we've run a recent webinar on setting up tenancies and tenancy agreements, but the checklist of documents that you have to provide to your tenancy. Under the new regulations for GDPR, you need to have a privacy policy and you need a copy of that to give to your tenant. The tenancy agreement itself should, in my opinion, be in writing. They don't have to be in writing, but obviously if you're going to rely on it later down the line, it is best to have them in writing and it's best to have them
100%.
signed. The
100%
How to
agree.
Rent Guide, yeah, the latest version of this is available online. We can send you a copy of this. I think there is also an article on our blog section which gives you this link. But it is that easy to find. Just Google How to Rent Guide government and it will take you to the government website. You need to give them a copy of this and it can be served electronically. You need to protect the deposits with a government approved registered scheme, and this can be either a custodial scheme or an insured scheme, all of which is your choice. But the scheme that you use, you must provide your tenant with that prescribed information and also a certificate of the protection. There's the copy of the energy performance certificate and the most up-to-date gas safety certificate, which you must renew annually, and upon every renewal, make sure a copy is provided to your tenant. And then the final one is you must complete a right to rent check. Now that is really important when we talk about insurances. So if you have some sort of arrears or possession insurance, rent protection, rent guarantee, you must complete this right to rent check. A lot of those underwriters are now becoming savvy about this, and they know if you haven't completed statutory requirements at the start of a tenancy, you could invalidate those insurance policies. So just make sure you've completed that right to rent check. You've got a physical document photographed with your tenant holding it and any occupier over the age of 18. And we would recommend that you insert that into your inventory document, and then it stays on file permanently. But you definitely must keep these for at least 2 to 5 years. It's also best practice to make sure you have your electrical safety done. You have an EICR. Now there are new standards coming in for electrical safety and EICR, which will likely lead to the fact that you have to have these carried out and completed and handed to your tenant before the start of a tenancy. It's good practice to make sure they've got instruction manuals for any appliances you're providing. Carry out a Legionella's risk assessment is required under health and safety. Provide an inventory, which is just a really simple document that stipulates the condition of the property at the start of the tenancy that you can then rely on at the end of the tenancy if there are any issues in there that are excessively beyond fair wear and tear. And then the payment information for the rent, so how are they going to make their rent payments and how often do they need to make those rent payments. Also really important when it comes to managing arrears. So tenant vetting, Alex, I know you're a big fan of making sure tenants are completely vetted before you get into a tenancy.
Oh,
as it
absolutely,
helps.
Alex. Yeah, and you know all the documents you've just mentioned as well. Just very very briefly to say, that's really, you know, prevention is better than cure. And it really is absolutely the case here. You know, I'll later go on to talk about accelerated possession claims. So, you know, the quickest route to regaining possession when you hit a problem. You talk about the AST there, Alex. You know, that is a fundamental document. And if, for example, you don't have that document, you can't issue a claim later on the accelerated possession claim route.
Yes.
So getting all of this stuff right at the very beginning will really help you reduce the problems later. Where we hit more difficult sort of claims and scenarios is where, unfortunately, a landlord has been caught out by not perhaps being as sort of super on top of documents and compliance. But, yeah.
We had 2 questions just on that documents before we go into tenant vetting. Steve, you asked a question about the right to rent stuff. The right to rent should it can be done after the AST has been signed. The right to rent should only be done once the AST is established. So some landlords sign the AST in advance of handing over the keys, but at the point at which you hand over the keys, that's when you should be doing your physical photographic check. So some reference agencies, some agents claim to do the right to rent check on your behalf without physically checking the document against the person stood in front of them. That is not a valid right to rent check. That is just an indication of whether or not you will need to get further documentation documentation. Here at MakeUrMove, we don't do that. We don't do any remote checks whatsoever. We advise you and give you plenty of information about how to do your own physical right to rent check when the tenants move in. We have been known to highlight where potentially we know that they're going to need additional documents such as visas, working visas, and you get copies of those, and we can get copies of them, but you still need to physically check them when you hand the key over. If we were doing a check-in and we were handling over those keys, yes, we would absolutely make sure that everyone over the age of 18 is attending at that check-in, and we will photograph it and put it in that report for you. So I hope that answers your question, Steve. Joanne, there is a question about the Legionella risk assessment. Alex, you probably can come in on this actually. They're asking
Sure.
if this assessment is a requirement or just recommended.
Yeah, and there's a lot of guidance on this, and the short of it is, and I'm sorry to be brutally honest, but does everyone have to sort of complete the assessment? The answer is yes, but in terms of how that assessment is conducted and the formality of it, the answer is that fundamentally there is no requirement to say, for example, pay somebody to go through a property and complete this check. A landlord with a little bit of nous and reading up on particularly the Health and Safety Executive, the HSE guidance on this, will be able to do it yourself. So it's not something that adds huge sort of friction, or rather shouldn't, but I do think it's one of those things where there's been a raft of stuff pretty recently in the last few years, and it's kind of a little bit panic stations with a whole sort of industries sprouting up to sort of kill your margins and encourage you to spend money, when actually I think this is certainly one where you can do it yourselves with almost no input really. Perhaps we can follow up with the Health and Safety Executive link.
Yeah, I think you can get. I think they do offer a template actually for things that you must check. So it's a risk assessment as opposed to a check that's required by somebody who's trained in that manner. So it's more of a, is there a risk of Legionella as a result of the water supply or the drainage or etc. in your property? And there is, the HSE, I'm sure, have a checklist for this. It came in at the same time as the smoke and CO2 allowance, which I remember there being a bit of a panic as well, agents everywhere sending letters out. So yes,
that's
it is required.
Act,
but it's required, but there is no formal requirement for it to be in a certain type of document, and you don't have to provide a copy to your tenant, but it is probably good practice.
100%. And just really briefly on Steve's query, Alex, I would just add, in terms of right to rent and all of that kind of thing, it's an additional obligation, but think about this in the context where you are effectively providing a tenant with credit. So for you to know who you are dealing with is actually a really good idea. Is this a solid person for you to be offering credit to in terms of your property, your asset? So knowing who you're dealing with and referencing them in terms of their ability to pay the rent is, to me, a little bit of a no-brainer if we're thinking of this as a business, which really we must at this stage.
Yeah, I totally agree, and that moves us on nicely to tenant vetting. Before you even get to that stage, check whether or not your tenant is going to be a good tenant, and it is a risk. It's a risk assessment basically. So you need to first understand, is it required? One of the things that we often tell our landlords is make sure you're checking your conditions of certain documents and requirements that are put on you by your mortgage company, your buildings insurance company, and your leasehold conditions if you have a leasehold rather than a freehold. Most of these, if not all of them, will have some reference to the type of tenants that you can actually let to, and they will make reference to having completed tenant reference checks that are satisfactory as well, even if it's just in the form of a credit check. The why it's important and how it helps, as Alex has just touched on there, if you vet someone in advance, you're going to flag up any potential issues. But the biggest one is you can verify what you've been told. It's really easy when it comes down to wanting a property to sell yourself in the best possible light. We often get references done where tenants have told us in advance, they earn £22,000 a year, and actually when it comes down to it, it's more like 18,000. But it's nice and easy just to top that up if you think you're going to get the property. So it is important, and you also need to establish what your risk is and make the relevant provisions. And what I mean by that is, it may be that you actually really like this tenant and they've got a really good record and an excellent credit rating, but they just don't earn quite enough to be comfortably paying this rent for a long period of time. So you might decide you want a guarantor. All of these things will be flagged up during the referencing process. So I would always say do your tenant vetting. And then we'll quickly move on to how we handle arrears. Here at MakeUrMove, when we do all our rent schedules, we set up schedules of rent payments, and we work out when they're due, what the dates that they're actually paid, and the amounts that are actually received. And we produce statements for our landlords. But this is really more of an etiquette thing. The real key thing here is to keep a really good record of the rental payments that are due and the actual dates and amounts that you receive them. And what we mean by arrears is beyond 28 days. I don't think anybody would really fuss over 1 or 2 days. I know it's inconvenient if they're doing that regularly, but if you factor in, weekends, bank holidays and things like that. But one of the key things to talk about with your tenant, if it is regularly late within 2 or 3 days, is to speak to them about setting up a standing order rather than making manual payments, which is usually the reason why it's late. The other way as well is if you've got a tenant, they've not made any rent payment, it was due, is just make sure you contact them by any permitted methods that you've set out in your AST or your privacy policy. Don't ignore it thinking that it will go right. If they are regularly a day late, doesn't matter. Make sure you're still contacting them on the day that it's due and you've not received it. Even if you know, or they normally pay a day late or 2 days late, because that you kind of create an acceptance of that behaviour if you don't. You also need to write to them, so put it in writing. So just write to the tenant outlining the specific clauses that they're in breach of once they get past certain stages of arrears. On this as well, we normally get some questions from our landlords about whether or not they can start to charge interest. Yes, you can. If it's in your tenancy agreement, of course, you can charge interest. In practice, it's not usually that much, and most landlords don't bother because ultimately they just want to have their arrears paid. There's an underlying issue, there's an underlying reason why your tenant's not paying rent, and sometimes this could just be a set of circumstances that they've found themselves in, and you as the landlord may be able to help them get out of those circumstances if you were willing to work with them. And I know lots of our landlords do this all the time, so keep a record of the contact that you have. It is best practice to contact them on the day it's due. We follow a process of then contacting them again the day after, 3 days later, 5 days, 7 days, and then every 7 days thereafter, until even if we get confirmation of when that's going to be paid, we will still follow up with them. You need to check your rent protection and your insurance policies as well. If you have rent protection or guarantee insurance, it's likely that they will have minimum requirements for you to contact them, and they will also require that you keep a copy of that record as well in order to validate the claim should you need to make it. And then the best thing is just keep calm, make sure you tackle the issue before it's too late. One of your things you mentioned, Alex, is just no head in the sand. Just make sure you take this head on. The earlier you deal with this, the less likely there will be a longer problem. So. The do's and don'ts of arrears management. Now, as landlords on this webinar, I'm sure you all know a number of other landlords that have told you certain stories about how they deal with certain things. There are ways to do it and there are ways not to do it. As I said already, make sure you're in contact with your tenant. Set deadlines and agree dates for further communication with them. If you are told something has gone on this month and they won't be able to pay you for another week, make sure that you're saying to them that needs to be in a week. And if there are any issues, you need to get in touch with me before that, and I will follow up with you on this date. And that just then make sure there's a clear communication. As soon as that communication channel closes down, that's when you start to have real issues with arrears. So just make sure you're keeping that communication open. Keep a record of anything that you have agreed, preferably in writing. Check that you have everything in order administratively. So this is checking that you've done all of your checklists with your documents in advance, that you've got copies of all of your records of communication, that you've got records of the arrears itself, or the rental payments that were due, etc. What not to do, don't ignore the issue. It's not going to resolve itself. It will be a persistent problem if you allow it to be a persistent problem, and it will get worse if you don't try and deal with it right away. Don't lose your temper. This is obviously, it's quite a stressful process for landlords. This is your asset at the end of the day. This is you agreeing, like Alex has said, you're giving credit to somebody to live in that property, and 9 times out of 10, you're going to have bills associated with that, whether that's a mortgage, whether that's insurance, that you need to make sure that you can pay. And landlords largely can't afford to take much of a loss on these things, otherwise it does really badly affect their incomes. So don't lose your temper. Losing your temper with tenants isn't going to help really get an understanding of what the situation is and why it's happening. And then do not, under any circumstances, access the property or change the locks. You do not have a right to do that. There are laws that protect against this, and if you fall foul of them, there are significant punishments in the form of custodial sentences. Am I right, Alex? And also fines.
Yeah, it's an absolute humdinger this in terms of unlawful eviction. That's broadly where we're at, and Protection from Eviction Act. You can be in for thousands of pounds worth of damages, but equally, I've dealt with situations where unfortunately landlords have taken these steps, and tenant will turn up legally aided, so with legal aid funding, and the first the landlord knows about it is when they're facing an injunction to allow the tenant back into the property, and a claim for thousands of pounds worth of damages, plus their costs, plus the landlord's own costs. It's a hell of a mess, and not something to get into, to be honest.
Yeah, I totally agree. So now we're going to move on to when to serve notice. So we did kind of touch on this earlier, the different types of notice that you can have. We talked about the 14 days and the 2 months. So just tell us a little bit more about the Section 8 notice, first of all, Alex.
Sure. Okay, so in terms of when to serve notice, I would say, firstly, when you're having conversations with tenants, always best to be on the front foot. Okay, so if there's a problem, the question is going to be how are you going to resolve that problem. The notices that we're referring to here are the formal way to resolve that problem. Okay, if you don't reach an agreement with tenant, if they don't rectify whatever the issue is, these are the routes by which you can use the courts to obtain an outcome. So having conversations with these floating around in the background will ensure that you're on the front foot, I would say. Obviously, you're going to have conversations informally first before you take these more serious steps. But again, it's sort of very tempting to emotionally engage. Oh, they've told me it will be next week or the week after. And again, this is where you start seeing claims for by landlords where months and months of arrears have accrued. Being proactive about dealing with this is really key. So Section 8 notice. This is a fault-based notice. It's a 14-day notice. So we're saying to the tenant, I'm the landlord, you are the tenant, you are in breach of the AST for these reasons. I am therefore going to evict you, and I'm entitled to possession. And within that 14-day period, it gives the tenant the ability to rectify the breach, whatever that is. So here you can see there are discretionary versus mandatory grounds. Grounds 1 to 8 are mandatory, and that really, when I say mandatory versus discretionary, this is fast forward, you have to issue a claim. A judge looks at it. If it's a mandatory ground, then a judge has no discretion and must order possession to you. Whereas if it's a discretionary ground, disaster, a judge could look at it and could say, difficult times for tenant, certain problems that have now been resolved. Therefore, yes, you win, in inverted commas, as a landlord, but you still don't regain possession. So the net result of all of that is that we would say, don't ever consider issuing a possession claim based on discretionary grounds, because you still incur all the costs, you still take all the time, but you don't have the certainty of winning at the end of it. So mandatory grounds rather are what we're really interested in. And ground 8 is really the killer on rent arrears, whereby a judge has no discretion if rent arrears are equal to or more than 8 weeks or 2 months, both at the time of service of the Section 8 notice and at the date of the hearing. So key sort of reference point there, if there are 2 months arrears when you serve that Section 8 notice and there are still 2 months worth of arrears at the date of the hearing, effectively a judge has no discretion and must order possession to you. So that's a Section 8 notice. It's a fault-based notice. Now, earlier on, we just touched upon the risk of counterclaims, because, of course, a judge could see that there are arrears of equal to or more than 2 months at the date of the hearing. But, of course, tenant turns around and says, oh, hang on a moment, I've got a counterclaim, and that counterclaim is for 3 or 4 months worth of rent because the property is in disrepair. Here's a photo of some mould because I've not opened windows and haven't ventilated, or some problem. And a judge at a possession hearing will say, in all likelihood, I don't have time to deal with this right now. I'm therefore going to adjourn it off with directions. And again, this is where you can see that with a Section 8 claim, where say you face a counterclaim, that route can take longer ultimately. So even though the 14-day notice may appear attractive, and it might be useful in terms of trying to engage with the tenant, to then issue a claim based on that notice, you're opening the door to further delays, or at least risk of delay in terms of a counterclaim. So just something to bear in mind there, particularly in the context of the alternative, which I mentioned below here, which is a Section 21 notice. Now, Section 21 notice is a 2-month notice, so that effectively is one of the problems with it, I suppose, if you look at it. So you're a landlord, you're facing a tenant with rent arrears, and I'm telling you to wait another 2 months. Well, I can see why that wouldn't necessarily be attractive on the face of it, but I think there's very good, sound reason for it in terms of the process. So you serve that notice, you allow 2 months to pass, and it then opens the door to, as I mentioned earlier, an accelerated possession claim. Now, as a starting point with an accelerated possession claim, there is no court hearing. So in other words, we're just saying to a judge, I'm the landlord, they're the tenant, I've served a valid notice, and I'm entitled to possession. And a judge will look at it on paper and will make an order on paper as long as everything is in sort of vanilla order and apple pie sort of standard. And that's where Alex's reference to all of the documents you need at the outset really kicks in, because you need to make sure you've got your AST and have dealt with all of the deposit properly. But assuming that's right, you will then obtain a possession order without a hearing. And so when you take all of that into account, it can actually be quicker and simpler, and it is, frankly, quicker and simpler to rely on a Section 21 notice, even when tenant is in arrears, mostly. Obviously, different cases have different issues, but 9 times out of 10, that is the reality here. That said, you can see in terms of the second bullet point there, the biggest issue with these notices, these are standard notices, okay? They come in a prescribed form. There's a government link. I know we will follow up afterwards with this to help you all. There's no issue in terms of the content of a notice. It's self-explanatory, but there's a huge problem ensuring they are valid, because that's the key. And again, we see so often where people have served their own notices, but they're not actually legally valid. And it might be that, for example, the deposit wasn't protected in time. That will invalidate a Section 21 notice. It might be that the deposit certificate, but not the leaflet, together forming the prescribed information, weren't provided to tenant in time. There's any number of factors that can invalidate a Section 21. Again, that's a problem, particularly where it takes 2 months for you to then be thinking about issuing the claim. So making sure that notice is valid is an absolutely killer point here in terms of saving your time and ultimately your money. And again, sorry, go on, Alex. Yeah.
No, sorry, I was just going to say, yeah, that it's one of the things that we get asked a lot is the Section 21 notice is when you get to that hearing stage and then you discover actually you didn't lodge the deposit within the set time frame, or the tenant's claiming they didn't get that notification and you can't prove otherwise. Yeah, it's hugely important. It does cause delays, but one thing I just wanted to point out, and I know we're going to touch on this a little bit later, is it is still never too late to then seek professional advice on this to try and deal with the issue.
Yeah, absolutely, Alex. We quite often we're instructed in the context where someone has already served a notice, and they've then hit a problem at some point. That's not at all unusual. So yeah, wholeheartedly agree with that. There's a sort of a whole raft of reasons that can invalidate Section 21, from improvement notices, from what's known as retaliatory eviction. So if tenant has raised issues in terms of the condition of the property, you must provide an adequate response before you serve a notice. From licensing issues, deposit I've mentioned, but you've also got to serve your EPC, your gas safety certificates, all of the things that Alex was mentioning earlier in terms of the requirements, and really being on top of the paperwork, the compliance stuff. This is where it becomes important, because if you're not on top of that at the outset, you can't serve a valid Section 21 notice. And so this is where I would always say, for those reasons, make sure you're on top of it at the very outset, to help really later down the line.
Yeah, and one of the other things that we would recommend is just storing them digitally. We find that landlords store them paper-wise. They might not come up with any issues for 2.5 years into the tenancy, and then they don't know where they put the documents.
And again, from my point of view, Alex, this is evidence. Okay, we talk about this in terms. You mentioned the rent schedule and what have you. I'm very interested in all of that where we act for landlords, because it's evidence. It's evidence that I can put before a judge to secure your orders as quickly as possible. And so you're really teeing things up in that sort of a way to help
Yeah, it makes a huge difference. Just before we go on to why engaging a specialist solicitor, one of the things I wanted to ask for the Section 8 notice is we often have landlords that come to us and ask us to do the section notices for them. And when we serve it, we tend to look at the mandatory grounds, but then look at the discretionaries and do combined. So with rent arrears, we'll use grounds 8, 10 and 11.
100%. Yeah.
And that is just to kind of sort of help the judge come to a reasoning that actually this is an ongoing issue. They might be only 2 months in arrears now, but they have been persistently breaching these contract terms for the last 10.
Absolutely right, Alex. Yeah, no, absolutely right. And I mean, I sort of we would use absolutely everything available. So 8 to 10, 11 is absolutely right. But I guess behind closed doors, it's important that we have this conversation about mandatory versus discretionary. So, yeah, all good, agreed.
So we'll go on to why use a solicitor then? What the pros and cons? Obviously, most of our landlords on here will have experience dealing with arrears and probably also solicitors as well. So yeah, let us know.
100%. Well, the first thing to say is you absolutely don't have to. It may sound perverse, but you're absolutely able to deal with this yourselves, and that includes the notices, the issuing the claims, etc. A lot of landlords do that successfully. So, again, I completely see the friction and the bias that you might assume I have, but I'm so relaxed about that because the reality here is I think the biggest reason probably for most landlords in this area of law is really to save your own time. And we're not talking huge costs here unless you're, say, using a traditional high street firm that are charging you by the hour. We charge fixed fees, and effectively we're saving landlords time across the country in doing that. There's obviously a layer here of complexity behind both the notices and the claims and the whole process, the ecosystem, I suppose, because although these are specific types of claims in terms of an accelerated possession claim that I've mentioned, and I think it was Steve's claim that he mentioned in terms of for both arrears and possession, they are still court claims. So all of the underlying process, legislation, rules, effectively, that govern complex litigation, they also apply to these same possession claims. So the moment you're pulled outside of a completely vanilla type scenario, for example, a counterclaim or a question mark over validity of notice, etc., you're going to start hit sort of roadblocks here in terms of your ability to pursue it. And do most landlords want that hassle? Do they have the time to do it properly? Do they want to have to pick up that friction as well when they've got other things to be doing? Very much a commercial call for individuals. As I say, very relaxed about that. But that's why I would say instruct solicitors to save your time, to avoid the friction in terms of your lack of knowledge. And again, I often use this example in the context where I could go on YouTube and I could learn how to change the brake pads on my car via Halfords without any problem at all. It'd take me a hell of a lot of time, but it's certainly possible. The amount of information that is out there now is astonishing, and there's no question. I'd like to think I'm a clever enough guy to be able to do that. I could watch a few videos and give it a good crack, but my goodness, I've got better things to do with my time, and so I don't approach this from the sort of I don't know, highbrow perspective that people can't issue their own claims. You absolutely can, but it just takes time and it's hassle, and I would like to think we can save that time and hassle and get it right for your first time. So that's the first reason. Second reason is just whizzing through these. Equality of arms. Tenants, unbelievably, will qualify normally for legal aid. That means that you're going to be facing solicitors. I've seen barristers, by the way, turn up represented by legal aid at possession hearings. Are you going to be confident in dealing with that if holes and allegations are made? The rules of evidence in terms of serving witness statements and what have you. Some of you will be, and that's absolutely fine. For others, that sounds like digging a hole, and you won't want to face that, which I understand. And again, I've mentioned here errors and mistakes we've touched upon. The biggest problems are people serve what looks to be a simple notice. They leave 2 months and it's not valid, and so we're starting again. Is that penny wise, pound foolish? I leave the question there. I don't know. But from my perspective, it might be in the context of ultimately this is an expensive asset. It's worth a lot of money. Let's regain possession of it as quickly as possible. They're the reasons. And the con, obviously, is that there's a cost to that. We charge money. I make no apologies for that. But for our part, our fees are fixed and we're uber transparent. And that's me speaking for myself and for my firm, Helix Law. Others will obviously deal with it perhaps on a time basis, be more expensive, what have you. But that's certainly why I would say to any landlord, instruct a specialist solicitor.
Yeah, and one of the difficulties as well is the landlords that are successful in getting these claims through still don't really understand the value of a solicitor, because it may be that they got their claim through just 3 months longer than it would have taken a specialist solicitor to do it. So it is very much about weighing up your own risks and your own costs, isn't it?
100%.
Yep. So I completely agree with you. I think the eviction process, one of the things that we get told a lot as well is don't rely on your agent to do this for you. They cannot do this for you. As much as they try and give you that, you have to do this yourself. You need to do the court, the possession claims yourself. It has to come with your name on, not your agent's name on.
Yeah, no, I completely agree. There's actually case law where cases have been thrown out for that reason alone now.
Yes.
So, eviction process. Again, we can whiz through this. I suspect a lot of landlords will know this, but you're really identifying the problem. We're then serving a notice, be it Section 8, Section 21. We're allowing that notice to expire, and then we're issuing the correct type of claim for the notice. And again, this might be a relevant issue for Steve earlier, but there are different types of claim that can be issued. Our preference by far is a Section 21 accelerated possession route claim because it's quicker. And so that's why. I've mentioned here in item number 3 on the slide, ensure you comply with court orders, file witness evidence properly to protect your position, and that justice doesn't just happen. I do see circumstances where people say to me, "Oh, it's outrageous that my claim's been thrown out. I've done everything. They're in huge arrears, etc., etc." But it's because they've not served a valid notice, and I have very little sympathy, being brutally honest, because this is the business we're all in. Okay, I'm a landlord myself. You have to get up the sort of curve here in terms of dealing with this properly. It won't just happen. So, and that's right in any litigation. You have to put forward your best case. It's not a sort of fait accompli that you will regain possession, that you will obtain an order for your arrears. You have to present your case properly and thoroughly, and then you will, and you'll succeed. So we issue your claim, obtain your possession order, either at a hearing or on paper. And at that stage, normally a judge will order possession between 14 and 42 days later. The standard order is 14 days. And normally tenant won't leave then either. Huge issue at the moment nationally where local authorities are saying to tenants, don't leave, sit tight until bailiffs are instructed. You therefore have to wait for that possession order to expire, and then you go back to court and you say, please can we get a bailiff's appointment? Now, at this time of year in particular, if you're issuing a claim now or even last month, you're probably looking at Christmas time for bailiffs. And of course, well, I say of course, but the courts won't arrange a bailiff's appointment over the festive period. So they're likely to be delayed into January. But that's all built into the 3 to 6 months. When I say that's the average sort of time to obtain possession, that includes instructing the bailiffs, as long as it's vanilla, as long as it's all presented thoroughly and properly, and as long as your notice is valid, etc. So bailiff's appointment is made. We know the date, we know the time. You might attend, you might have a representative attend, probably better if it is you, to be honest. And you arrange with a locksmith. The bailiff will ensure the removal of tenant. Locksmiths change the locks, and that's it. You're back in. So at that stage, you're in possession of the property, and you can start going through your sort of next steps. Completely separate to that, I've mentioned in item 7, enforcing the money judgment, CCJ. So in terms of any rent arrears, etc., you can start pursuing those at that stage as well. Always difficult with tenants in the sense that as a starting point, the outlook is not positive in terms of whether or not they have assets or means ability to pay arrears. And again, it's very circular. That's why it really pays dividends for landlords to get on top of this sort of an issue quickly, because the prospect of you being able to recover significant arrears into the future is at best questionable, I would say, unless you're in a high-end property market and with perhaps a guarantor, etc. So getting them out as quickly as possible, frankly, is going to be important to minimise the impact on you as a landlord.
Yeah, and one of the things with the CCJ as well is we always say to landlords, and I know it's difficult once you've been doing this, it's just consider going for that CCJ, because it is a warning to other landlords down the line that this has happened. So
I agree.
If not for yourself, just do it as a favour for other people, and hopefully someone will do that for you as well. So
yeah. Agreed.
So moving on then, so you've got your possession of your property back. You are now dealing with the release of the deposit. You do this in the way that you would do any normal tenancy handover. So you carry out a condition record, which is a checkout report. You photograph anything, you compare it against your inventory report, and you lodge any claims against that deposit. Now, you may also be able to deal with this during the possession process. Am I right, Alex? You may be able to get an order from the court to say that the deposit will be returned to you in full.
Yeah, it's definitely worth asking. Again, different courts adopt a different process, which sounds scary but is honest. So, for example, Central London County Court, they're not interested. They have a blanket sort of go back to the DPS and deal with it, and they won't make orders. Whereas different regional courts, you might be able to chance your arm and get it through. So don't ask, don't get, basically.
Yeah. There's no risk.
Always ask.
Yeah. You need to provide a copy of this and a list of any retentions that you want to take from the deposit for conditions and also for arrears to your tenant. Ideally, notify them within 10 working days as per the requirements of the deposit, and then submit that claim to the deposit service that you've used, whether this is a custodial or an insured back scheme. You still need to submit your evidence. If you have that court order, submit that at the same time, and the scheme will then process it through the court order. Getting your property ready for remarketing. Now, we've all heard these horror stories of tenants have left all the possessions. They knew they were being evicted. They had all the notifications, but everything is still there. There's loads of rubbish, etc. There are certain things you have to do when it comes to tenants' possessions. One of the things is arranging for them to get access to then come back and take their possessions. You can give them a timeline. You can also serve notice on them that you may consider, as long as this is in your tenancy agreement, the sale of some of these items or the storage of some of these items for a set period of time in which they need to make a claim, and then after that you will sell them to cover the cost of those. Now, this is a little bit, it's not black and white. It's a bit of a grey area regarding some of the laws out there. Am I right, Alex? It's a little bit confusing for landlords about whether or not they have the right to remove those possessions.
Yeah, I could bore everyone to death about this.
Yeah,
but I won't.
The truth is it's there's not. I don't think there is many cases that have gone through where tenants have actually pursued landlords for the removal of possessions after.
No, I think what I would say on this is, again, it boils back down to your inventory. So being clear on the condition of the property. You are, as a landlord, when you go back into a property, you're what's known as an involuntary bailee. So you do have a degree of obligation in relation to those possessions. The way I always advise people to deal with that is to effectively ensure that you have a clear schedule, effectively still do a checkout when you go back in, so that there's some contemporaneous evidence of the condition of the property and whatever is left, if anything, in the property afterwards. This is just to avoid a scenario where a tenant rears their head in a few weeks and turns around and asks where their 30 laptops are or something like that. You just need to have some contemporaneous evidence to push back against that.
Yeah. And then, once you've got that property ready, you cleared it out, you've got an agenda, a list of works that need to be completed, get them done. Check your insurance policies as well if you've been making a claim through your insurance. A lot of them do have post-eviction, they'll pay half a month's rent for post-eviction over the 2-month period, as long as the property is going to be remarketed. So you need to get it remarketed within that 2-month period. So do make sure you keep an eye on those clauses. Don't be put off by a bad experience. I've spoken to so many first-time landlords who have been caught out, who have ended up spending a year trying to get rid of the tenants, have finally succeeded, and the first thing that they say they want to do is sell it. They just don't want to do it anymore. This is an experience for you that you will not repeat. If you can avoid it, you will. And the point is there are plenty of good good tenants out there. Sorry, as Alex said at the beginning, 91% of tenants go without a hitch, and a lot of those are ended by the tenant quite successfully, and there's no issues with handing that property back. So don't be put off. Make sure you get back on it as soon as you can. So get your marketing back up, and this time make sure you follow as many protective, preemptive measures as possible to make sure you don't end up with a tenant that's not going to pay rent. The future. So we've talked about the Section 21, and we talked about Section 24. Alex, we know Section 24 tax changes are coming in. They're being phased in slowly. It's having an impact on the stock levels, and is likely to have an impact on stock levels in the future. The biggest issue with this, I think both of us would agree, is that it's likely to push rents up.
Yeah. I mean, the truth is, we all know this is an environment at the moment where there is increased regulation and compliance. It seems to me every week we're coming across new rules and regulations,
Yeah.
and some of them have been retrospective now in terms of historic tenancies being caught by the same EPC and gas safety requirements as newer tenancies. So being on top of this, using agents, solicitors where necessary, I'd like to think it adds value, not least in this environment with all of that going on. But just in terms of some specifics that are being mooted, I saw this week a bill has progressed through, I think it's second reading, it's now gone up to the Lords, where all property must be fit for human habitation, in inverted commas. That's a new one on me in terms of what that actually means, and of course, there is no definition of what that means at all. It seems to me that that's actually a likely of a rehash, having read through the draft bill, so this is only draft.
That is the case.
Laws.
They actually presented this at the RLA Future Renting Conference down in London, and the local MP, I think she's a Labour MP actually.
It's Karen Buck, yeah.
Yeah, so Karen did come out and say that this was a rehash of previously tabled
we see this.
legislation.
It's a great soundbite in terms of, you can almost see the press release. I've managed to secure that all tenancies are fit for human habitation, being the sort of the headline. When the reality is the standards are not actually changing.
They're not.
There is talk of abolishing Section 21s. It remains to be seen whether or not that will happen.
This is an interesting one. This is a very interesting one for me. Generation Rent have done some amazing work. Don't get me wrong. I like social bodies and voices that are raised for any parties within this rental sector. But what frustrates me with these is that they're so one-sided. And in my opinion, you have to take a view of the whole market and everybody within it to understand if policies and measures that are put forward are actually going to have a positive impact.
Yeah, I completely agree, Alex. I look at the statistics because I'm boring like that very often. And in terms of possession claims, for example, 65% of possession claims at the moment are actually issued by housing associations and local authorities, as in not by private rental sector PRS landlords, such that we're talking to today.
That's 2 out of every 3. Yeah,
exactly. Yeah.
And another interesting statistic was that I think we did a survey recently, and around 80% of tenancies that are terminated are done so by the tenant, not the landlord in the private sector, which means the further 20%, some of which will be done under Section 21 and some under Section 8. So there are lots of changes. The housing court is quite an interesting one. If you'd like to take some of these things from Scotland, they seem to come in there first and then get passed down, the tenant fee ban being one, abolishing certain acts. One of the things that Scotland have done is impose a prescribed tenancy agreement, and also make sure that all possession claims are then heard by a dedicated housing court, which is the first tier tribunal court. It's similar to here, I believe.
And I can see the merit in that, to be honest, in terms of the housing court in particular. We've seen this in other areas, so investors may know of leasehold, freehold type scenarios. And the first tier tribunal in England and Wales, they deal with those issues now already. So to pull this out of the county court would make sense. And there is this sort of public policy. There's this public policy agenda towards specialised courts, so I don't think that's anything to be concerned by. And for a lot of landlords, all of this other stuff is not actually something to be concerned by either. Longer tenancies, well, great. You're a landlord, you need tenants, fantastic. Abolishing Section 21, you'll still have the Section 8 route where there are problems. So, I think all of these things can be dealt with and addressed positively. It's just more ensuring that you have an awareness, particularly on the compliance stuff, to ensure that you're not sort of falling down.
Yeah, so I know, guys, I'm conscious of time. We are coming up to 11 o'clock, so I'm just going to quickly run through the key takeaways that both myself and Alex have touched on during the webinar itself. So get organised, be proactive and engage with your tenants throughout everything. So right at the very outset, open up that communication, get that dialogue going. keep it friendly, keep it professional, but make sure that you are tracking everything and recording everything. Reduce your risk by obtaining the core documents and ensuring that you have copies of those digitally stored, so you might need them in the future. Stay up to date with legislation, regulation, changes that you might need to be aware of in order to remain compliant. And as Alex said, most of them are progressive, but some of them are now affecting past tenancies, so you need to make sure that you might say, no, it doesn't affect me because it only came in October this year. Actually, it may well affect previous tenancies, so make sure you keep up to date with that. If you're unsure about any processes, always seek advice and consider appointing a specialist solicitor such as Helix Law to help you out with any possession that you might need to do, and make sure your notices are served. As previously said, there could well be cost involved, but that cost could be offset against the savings you'll make for time and also getting your possession quicker. Don't leave it too long. That's the biggest takeaway. So now, the last few minutes, before we go into this, I'd obviously like to thank Alex for helping us out today with the webinar.
No problem.
The next webinar we're running is how to prepare your property for winter. Yes, it is that time of year, unfortunately, and we all now need to start talking about boilers and heating, etc. Please do sign up to that. We'll let you know when that's going through. Any questions? I know we've answered a few throughout. There doesn't seem to be any on here. If you do have any, you can stick them through on your questions. You can put them through to me privately, or you can send them out to the whole group. If you don't have any questions right this very minute, but you do have something that pops up later, do feel free to get in touch. You can contact either myself or Alex. We can send out some information. You will get a copy of this recording, and you will also get a Section 21 Form 6A template along with some guidance notes for how to complete it. There doesn't seem to be any questions, Alex. Is there anything you want to say just to finish off?
No, just to thank everyone. I'm really happy to answer any questions afterwards. By all means, follow up, contact me via Alex or directly at Helix Law. Yeah, we're very happy to assist. We provide a free legal advice line to landlords, and I'm always happy to speak with the people, including informally, without charge. So happy to leave that out there if there's any follow up afterwards.
Perfect, and thank you very much for joining us today and for providing us with all that great information. I'm going to stop the recording now, guys. If you do have any questions, get in touch. Thank you for attending, and we hope to see you on the next one. Thanks, Alex. Thanks, attendees.